Court will call the case of Mark Mansick versus Rebecca DeVoot. This matter is before the court for a continued pretrial conference, as well as an order to show cause issued by this court at the request of the defendant, Rebecca DeVoot. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski, representing the plaintiff, Mark Mansick. Mr. Mansick is present with Mrs. Zagorski. Good morning, Ms. Zagorski. In addition,
good morning, Your Honor.
In addition, attorneys Kimberly Kuhn and Eric Chappell are present, representing the defendant, Rebecca DeVoot, and Mr. DeVoot is present with Ms. Kuhn in her office. Good morning, Ms. Kuhn and Mr. Chappell.
Morning, Your Honor.
The court overheard conversations between the court reporter and Mr. Walker from the court about listening to the recordings of a prior hearing proceeding to clarify language in an order. The court's opinion, let's just move forward. I mean, we're argue over a day or 4 hours or 2 hours of makeup parenting time. It's costing these parties a lot of money. And I think we need to clarify the order regarding pickups, drop-offs, timeframes, holidays, and just move forward. So that's court's opinion. Of course, the front of the court is making it easy because the front of the court's preparing these orders. If the attorneys think there's a discrepancy in the orders, the attorney should be preparing the orders. But of course, the front of the court has been kind enough to assist the court and the parties with preparing those orders. In any event, Mr. Walker, do you have a recommendation for the court this morning?
I do, Your Honor. I haven't put it in your queue, but I can read it into the record if you would like.
Okay, let me just, maybe I need to refresh here. There it is. Apologize for the delay. Maybe that Ms. Gorski, Ms. Kuhn, Mr. Chappell, the recommendation of Mr. Walker is that mother shall be told to make a parenting time of 2 hours for the time she missed on January 15, 2024, Martin Luther King Day, and that all future exchanges shall be at 9 a.m. Need to clarify the exchanges are either at daycare or if there's no daycare at the Saline Police Department. Is that what the our practice has been?
Yes.
Right. So perhaps we should clarify that, Mr. Walker. I'm not sure what else we need to clarify, that the all exchanges shall occur at daycare. And if daycare is closed, then it'll be at the Saline Police Department.
I will do that. Yeah.
There's some disagreement as to the makeup time as well as the time of the exchanges. So, Ms. Gorski, do you want to go first in terms of what's your client's position on this recommendation?
Yes, thank you, Judge. As I've acknowledged in my response, my client believed Martin Luther King was a holiday, and so he did have the child from 4:30 to 6:30, and it was not a front of the court holiday. We acknowledged that there were 2 hours there that needed to be made up. But with respect to the exchange time, my client is of the position that this 9 o'clock exchange is not fair to Maggie. She's been at Stony Creek Preschool for 2 years, and it is the only thing that provides consistency and stability while her family goes through this transition. And so he's of the opinion that Maggie should be allowed to go to school and that the parties should be exchanging at 4:30 after school. What mom likes to do is go and pick up the child from school after my client drops her off. And Maggie should be in school with her friends every day. She should have that pattern and that stability. The 9 a.m. exchange time doesn't do that because mom will go and get her from school. And he also notes that school ends at 4 o'clock. We intended that Maggie go to school, and at 4 o'clock, the parent whose parenting time it was would pick her up and then go to Celine and exchange her. So we think that the exchange should be 4:30 and not 9 o'clock. If it's my client's overnight, then he should have her the next day until 4:30 when they exchange. The 9 a.m. exchange time isn't fair to the child.
The whole object is to minimize contact between the parents, which is really unfortunate to think about it. Isn't that the whole thought behind this? Is that they pick up and drop off at school, and the only time they meet at the police department is when there is no school. And is there school during the summer too? Daycare?
There's daycare.
Yes.
It's daycare. She's 4. It's preschool. It's an educational daycare, Your Honor. So
Right.
My client doesn't pull the child out all the time. That is such a mischaracterization. And Mr. Mansick has pulled the child out. It's educational daycare, number one. It's not state mandated, as the court is well aware. 9 o'clock exchange, they drop the child off to the educational daycare at 9 a.m. The exchange is at 9 a.m. They're not seeing each other. They're only dealing with each other if there's no daycare. So yes, so we want to minimize the contact. Your Honor, I'll be filing a motion for my client to give vacation parenting time. Nothing ever occurs. These parties do not co-parent. They do not agree on anything. I had to file an ex parte motion for the child to even just go to a school for just to even get on the placement. So you are 100% right, Your Honor. They do not co-parent. They do not agree. The 9 o'clock exchange is the perfect exchange, because the less contact we have with these two at this point, the better off we are, Your Honor.
Right,
Judge, Ms. Kuhn didn't need to file an ex parte petition for Maggie to go to Emerson. My client was intending to take her. My client did take her on Friday, and in fact went back subsequently for his own private tour without the child with him. He went back on Monday. Maggie's already announced that she's going to Emerson. She told my client that because that's what her mother tells her. It's over the top. But all of that aside, the issue here is when parenting time begins and ends. And I'm simply asserting for both parents, if it's their overnight, they have the next day until 4:30 at the Saline Police Department. That's what the order says, and it makes sense. This child should be in school every day. It is an educational preschool, and she is getting the benefits of that consistent schedule.
Your Honor, we want to minimize contact. The 9 o'clock exchange, the drop-off occurs at 9 a.m. It's the other parent's parenting time. And with regard to Mr. Mansick's, if you look at the conversations on Exhibit 1 for the ex parte motion to even have the child go to school, you'll see the game playing. He never confirms it. And Ms. Zagorski saying, well, you should have gotten a hold of me. Well, if counsel has to sit here and micromanage, that's a clear indication that these parties don't communicate, don't co-parent. Mr. Walker's recommendation is a sound recommendation. And in fact, Your Honor, if you look at your order, the June order, it states that the above exchanges shall occur at 9 a.m. I don't believe, respectfully, that there's any ambiguity in that order. I'm asking that the 9 a.m. parenting time be reaffirmed or affirmed in the order that's before, that's part of that recommendation, Your Honor. It makes the most sense. It allows for the least amount of contact. My client plans on Maggie attending her preschool. So, there's been no motions before you by opposing counsel stating that it hasn't, that there's been an issue. There's no issue, Your Honor. But we would like the 9 o'clock exchange time. It makes the most sense. It comports with what was agreed on last time. I don't believe that there's an ambiguity, Your Honor. And with that being said, I'm asking that the court adopt Mr. Walker's recommendation. Ms. Zagorski and I can go back and forth on the 2 hours. Hopefully we'll be able to figure that out. I don't have any confidence that the parties will. So I can send Ms. Zagorski a 2-hour, window where my client can have 2 additional hours. I'll also be asking her about some vacation summer parenting time in May. If we can't resolve that, then we'll be back.
Again, yes, the order, and I've got the order in front of me, and it seems referenced that certain above exchanges shall occur at 9 o'clock. But what's been the practice other than, of course, this order references Father's Day, Mother's Day, and some time in July 4th and July 11th. What have the parties been practicing? obviously it's a 2-2-3 schedule. So the parent who has a child that weekend takes the child to daycare, correct?
Yeah,
Correct,
Judge.
In the morning, and the other
Yeah,
parent picks up after daycare?
no, mom has been going and getting the child in the morning and I'll get the attendance records. Dr. Wooten has them right now. I will get the attendance records and I will submit them to you with a motion to have her stop taking this child out of school every day. What she does is she takes my client's time. She just goes and picks the child up from school. And the attendance records will show this. Dr. Wooten has them right now. My client does not do that. She goes and she picks up the child. So Maggie doesn't get the benefit of being in school all day because she thinks her time starts at 9. My client thinks her time starts at 4:30 and his time starts at 4:30. The child should be
So
happy. And that's my client's concern, is that Maggie is the one who loses with a 9 o'clock exchange. Maggie loses.
Right. Does that occur every Monday? Mr. Vu does not work on Mondays?
She does that on Monday, Wednesday, Friday, I think, right? Goes and
No,
picks
she
me up
doesn't.
Emily, she picks her up on
Fridays
for a long weekend.
at 9.
Yes,
Okay. So she takes her out on Fridays.
but the intended,
No, Judge,
he takes her out often.
Judge, it's a preschool daycare. It's daycare, number one. Number two,
Not
if she
daycare.
takes her out, or it is a daycare, it's an educational daycare. She's 4. It's not even state mandated, Your Honor. She is in school on Fridays. If my client picks her up a little early for a long weekend, there's no issue. And
Well,
as I stated before.
Children need consistency and continuity. So what right now, so does mom pick her up just on Fridays or just Mondays, or just is it random? She just picks her up. I mean,
Random.
most kids like that to see their friends. I've got grandchildren that are 6 and 4. They like their school, even though it's not state mandated. It's certainly it's more than just babysitting. It's preschool. So what is her schedule? The child's schedule right now? Is she there Monday through Friday or just?
Monday.
And who pays
She's
for it?
Monday through Friday, 9 to 4, and mom
paying
goes
for
and
it?
picks her up randomly. And Judge, so my client's never been happy about that. He didn't rush into court and accuse mom of wrongdoing. When we talk about co-parenting, I think it's evident what's going on here. Mom makes the rules however she sees fit. And so this kid is the one who loses.
That is
So
so not true.
I'm trying to understand the past practice. For example, if it's dad's weekend, then dad takes the child back to school on Monday morning, correct?
9 a.m. And then it's mom's time. Exactly. The exchanges have been at daycare at 9 a.m. That's what we've done.
But that's not an exchange. That's dropping the child off at school. The exchange per the order is at the Saline Police Department at 4:30. The intent was that Maggie would be in school all day. She gets out at 4 and then my client could drive her to Saline in 30 minutes.
Mr.
That
Dorsey,
was the
read the
intent.
order. That's not the intent. Exchanges shall occur at child care facility. If no child care, parties shall meet at Saline Police Station at 4:30. The
Correct.
exchanges occur at 9 a.m. If there's no child care, then at 4:30. There's always child care. It's a child care facility too. Your Honor, 9 a.m. makes sense. My client doesn't need to meet Mr. Mansick. Mr. Mansick can't even give her a okay to take the child to Emerson. Look who's playing the games. We don't want to put these people together more than what we have to. If we're exchanging at 9 a.m., if you want my client to say, okay, she will be in daycare, she will pick her up after daycare on her days, you'll do that, correct? Sorry for clarity. What do you? So not pulling her out early, even though it's daycare. You'll leave her in daycare Monday through Friday on your days, correct?
On my days?
Yes.
But because of my schedule, a lot of times, every time I took her out early at 9 a.m., I emailed Mark through App Close, and that's what I would do. I wasn't hiding it. I have to sign in when I would do it. A lot of times for me, because my job is in 3 different locations, it's easier to go pick her up.
But can't you stay in until, so you were only taking her out for 2 hours early?
Yeah, sometimes it was just 2 o'clock. I would run over there because of other things. It's not the only times I took her out at 9 a.m., around 9 a.m., Mark received some kind of communication.
How late is the daycare facility open until?
6 o'clock.
So really it ends at 6 p.m.
Mhm.
So if you're taking her out at 2, it really ends at 6 p.m. anyway. And you're all taking her out at 4 anyway. So that's a time that you've chosen to
And
take her
time,
out.
4 is the time Mark chose. Sometimes I pick her up at 4:30. Sometimes I picked her up at 5. It depends on my schedule. My schedule
All
has
right.
always been different.
All right, thank you, Mr. Voot. We've got a very busy morning. It appears that if the daycare is on mom's time, she should be able to take the child out of school. And then likewise, dad. If dad wants it's a nice day, wants to do something with his daughter, it's his day, and he should be able to do that. But it does occur that all exchange should occur at the child care facility. So who's ever got the weekend, they take the child to daycare Monday morning, and then daycare begins at 9 o'clock, whatever time it begins. So do we need to specify time? It seems like the only time we need to specify time, and maybe I'm missing something. The only time we need to reference a time frame is when there's no school. And it appears that when there's no school, it should be at 4:30. Am I missing something?
No, that's what the order says, Judge. That I think the controversy is in those hours between 9 and 4:30.
And if it's mom's day,
it?
if mom's day, if she wants to take her, she's got off work, and she wants to spend time with her, take her to lunch, she should be able to do that. But then she takes the child back to daycare so that whenever it's dad's time, dad can pick her up, whatever, at the end of her Tuesday schedule.
But
Then, of course, the client is simply suggested with all exchanges occur at the child care facility, and if there's no child care, or should meet the Saline Police Department at 4:30.
Or 9 o'clock, Judge.
Present?
Judge, we can meet at 9 a.m. in the morning too. Why don't we just keep it all 9 a.m. since we have to keep coming back on these issues? My client can meet Mr. Mansick at the Saline Police Department at 9 a.m. and we can do the exchange.
Would the child be at Miss School? Would the child be going to school?
If there's no school. If there's no school, Judge. If there's no school, we can still meet at 9 a.m.
So the issue, Judge, is if it's, for example, Mark's overnight on Tuesday and he drops Maggie off Wednesday morning, whose day is Wednesday? Rebecca thinks that her day begins at 9 a.m. and Mark thinks her day begins at 4:30. It's that at 4, you exchange at 4:30. It's that, 7 hours in between that is the abyss. Rebecca thinks that that's her day, so she can go remove this child from the facility. Mark thinks that the child should be in the facility all day and that it's Maggie's time at school and that the exchange time is actually 4:30 and not 9 a.m. Do you follow me?
Yeah,
Yes.
but that makes no sense. If the exchange time is 9, that means the parent who has the child at 9 a.m. is responsible for the day until the next parent exchange. That makes no sense, Maria. I'm sorry. But if the exchange occurs at 9 and it's mom's day and it's her parenting time, she's responsible for that day. When she brings the child back for dad's exchange time, he gets the whole day. So exchange time at 9 means the parent who is coming into possession, that's their parenting time.
But they come into possession at 4:30 and they get 24
At
hours
9.
until 4:30. Until
At
4:30.
9.
Until 4:30.
No, Ms. Zagorski, if at 9 o'clock, if the child's sick and the parent whose parenting time it is, they're going to call that parent and say, your child's sick, come pick her up. That it's 9 o'clock is the exchange time. So mom would be responsible for the time that the child is in school during that time. The exchange time is 9. I don't understand why that's so difficult. It's very simple.
Because Mark or Rebecca is going to take the child to childcare at 9 a.m. or keep the child until 4:30 if there is no childcare.
9 o'clock
day because it was her overnight the night before.
That's why I'm asking that the 4:30 not be 4:30, that the parties exchange. If there's no daycare, they exchange at 9 a.m. If we make the 9 a.m. time consistent with whether there is daycare or there isn't daycare, we don't have that issue. That's why I'm asking, Your Honor, if we can not do an exchange at 4:30, if we can just do all the exchanges at 9 a.m. If there's no daycare that day, they can meet at the Saline Police Station and it's a 9 a.m. exchange. If it's Mr. Mansick's parenting time, he has her all day.
My client is asking that the child be afforded a consistent schedule and be permitted to go to school, that the parties exchange at 4:30. And that's what the order says.
If there's no school, she can't go to school.
And then she should stay with the parent in whose home she woke up. So if there's no school and she wakes up in Mark's house, he should have her until 4:30 that day.
He should exchange her at 9.
If she's sick,
If we,
she should stay in the home where she wakes up until later that day.
both parents, I'm sure, are capable of caring for a sick child. Your Honor, I would ask that you adopt the recommendation and that the exchange time be consistent, or we're going to be back. If we do a 9 o'clock exchange time, either the child's going to our educational daycare for the day, or if daycare is closed, they're going to be with the other parent. It just makes sense.
I will get you those records, Judge. Ms. DeVoot does not allow this kid to be in school all day. I'll get you the records.
Get the records, Ms. Zagorski, I'll get them too. So that is such a mischaracterization.
All right. Do we need to talk about the 2 hours? I mean, I don't want to come back next in 2 weeks to talk about the 2 hours. Let's address the 2 hours, make a parenting time
2 hours,
today.
sure.
And let's talk about summer parenting time today. So I'm going to have you talk with Mr. Walker about the 2 hours and summer parenting time. Lastly, the parties were mediated with Mr. Godfrey February 19th. What happened with that mediation?
Judge, we're waiting on Dr. Wooten's recommendation. It was rescheduled to June 4th.
Okay. And Mr. Walker, the other thing, the courts can order that both parties complete the high conflict solutions workshop. It's they can do it online. It's one word, high conflict solution. It's the plural, highconflictsolutions.com. Both parties are ordered to complete that class, and each party is to write a 100-word essay to the court with the copy of the front of the court of what they learned from that class. This child's 4 years old. They need to start co-parenting, and I've heard good things about this program. Perhaps it would assist for the benefit of the minor child. So I'll come back and I'll consider this recommendation of Mr. Walker, but I'd like the parties to agree upon. Let's tie down those 2 hours today. Let's talk about summer parenting time. It's March right now. Before we know it's now obviously the daycare, that's year round, correct?
Correct.
Yes.
But Ms. Gorski, the court's opinion is that yes, if the child's at daycare and maybe it's a beautiful day and mom or dad wants to do something, it's their day, they should be able to take that child out of school. Even though I agree that child needs to be primarily consistent in terms of going to school, but there should always be exceptions to that, some flexibility.
Well, sure. So if they wake up and they want to keep Maggie home for the day, they should be able to do that. And that's what I'm saying. They keep her home and then exchange her at 4:30. I agree.
Okay, let's have Dr. Mr. Walker about the 2 hours. Let's tie that down as well as the summer.
Okay. Back to the breakout room.
Yes, please. We'll call the case of Ashley Bailey versus Armand Bailey. This matter is before the court for a pretrial conference. The same is being conducted via Zoom. President Attorney Michael Keeney representing the plaintiff, Ashley Bailey. Miss Bailey's present. And sir, you are Armand Bailey, is that correct? You need to unmute yourself, Mr. Bailey.
He is unmuted. Maybe he needs to turn up his volume. It shows he's unmuted.
They met with front of the court, sir.
This is one you told me they didn't need.
Oh, okay. All right. Okay. Instructions to call in. We're going to give you instructions to call in. Mr. Keeney, do you want to talk in front of the court this morning?
Your Honor, I don't actually believe we need to do so.
I'm sorry?
I don't believe we need to do so, Your Honor. The only outstanding issue is one related to a minor child that was born during the marriage, who is not Mr. Bailey's biological child.
Okay. So the court will order DNA testing, so we need to argue about who's going to pay for the cost of that, correct?
And so I have spoken with my client, Your Honor, and maybe she can unmute herself to confirm that she feels comfortable paying for the DNA testing. She does have, she did name the father in the motion to exclude the minor child, the biological father that is. And I believe she feels comfortable covering the cost of genetic testing, especially if it happens to be an over-the-counter test, Your Honor, if you would allow. All the parties, including the biological father, are on board and agree that the minor child is not the biological child of Mr. Bailey.
And perhaps Mr. Bragg, the alleged biological father, can contribute toward that cost.
Potentially, Your Honor, yes. However, that was something that I spoke with my client about, and Miss Bailey said she would welcome anybody that would want to contribute to the cost of testing. However, she understands that the burden may fall on her, and she does want this divorce to move forward.
Okay, and again, she certainly, I'm sure, has some contact with Brandon Bragg and can suggest that maybe he fit the bill.
Correct,
Event,
Your
Mr. Bailey, can you need to unmute yourself or turn up your volume? You need to communicate with the court.
We've got the number here that Seth can read to.
Okay, we're gonna give you a phone number, Mr. Bailey. You need to call in, and then Ms. Bailey, you need to mute yourself so that you can talk with the court.
Hi, good morning, everybody. I don't know if you wanted me to unmute or.
All right, we need to wait for Mr. Bailey to return.
Yes, sir.
There's no audio. Maybe give the audio thing.
You need to turn on your audio, Mr. Bailey.
Here you go for doing an audio.
Miss Bailey, can you text Mr. Bailey and give him instructions? He needs to turn on his audio.
Yes, I will right now.
And if he can't figure it out, we'll give him a phone number he can call in.
Can you hear me now?
Yes.
Yes.
All right, Mr. Bailey, can you hear the court?
Yes, I hear you guys.
All right, the court's going to recall the case of Ashley Bailey versus Armand Bailey. This matter is before the court for a pretrial conference, as well as the plaintiff's motion to exclude a minor child of the marriage. This hearing is being conducted via Zoom. Both parties are present, as well as Attorney Michael Keeney representing the plaintiff. Mr. Bailey, you received a copy of Mr. Keeney's motion. There, Miss Bailey seeking to exclude the minor child born during the marriage from being a child of this marriage. You understand that?
Yes.
Legally, you are presumed to be the biological father of that child since this child was born during the marriage. So you have an obligation to support that child unless we exclude that child. So in order to do so, we need DNA testing.
I don't we haven't seen each other in 10 years.
Do you understand that, Mr.
That
Bailey? Well, you should have started a divorce a long time ago. This child, you're presumed to be by law the biological father. So we need DNA testing. Mr. Keeney, what is Miss Bailey going to?
He's there. I just turned on.
Okay, Miss Bailey going to cover the cost of that DNA testing, perhaps to her and Mr. Bragg?
Yes, I will.
Okay, the court's not real sure about this drugstore test. What's that, a $20 test, and it's just over the counter?
Your Honor, it's my understanding that the DNA tests are usually closer to $150. And we've used them before. Our office has used them before in the past. However, if Your Honor would prefer in-person testing, we can certainly do that as well.
Well, I thank you, Mr. Keeney. If you use them in the past, and if all three parties will agree as to paternity, I think that might be sufficient. Mr. Bailey, can you hear the court?
Yes. Yes.
Mr. Bailey, did you admit and acknowledge that Carson, not your biological child?
Yes, it's not.
Okay, you've been separated since August of 2016. What year was the minor child Carson born, Mr. Keeney?
I'm sorry, Your Honor, I couldn't hear you.
And Miss Bailey, when was your son Carson born? What year?
He was born in September of 2022.
All right. All right. Perhaps the thing to do is we can continue this pretrial conference for a couple weeks. Miss Bailey, you need to facilitate the appearance of Brandon Bragg with you. The court needs testimony from you and Mr. Bragg, as well as Mr. Bailey. Perhaps we can secure that testimony from the two parties this morning. Mr. Keeney, what's your thoughts? You want to wait till Mr. Bragg is here? Or?
Whatever Your Honor would find more efficient. I think both parties are willing to testify about the issue regarding the minor child. However, if Your Honor would find it more cohesive to have all three parties present to get all their testimonies at once, I think that would also be acceptable.
Okay. Perhaps we'll wait. We'll have the results as well as the presence of Mr. Bragg. Miss Bailey, can you secure the presence of Mr. Bragg at the next court hearing?
I can try. Mr. Bragg is on, well, he's just having a bad, I can try.
Miss Bailey, the court will not grant this motion without testimony of Mr. Bragg. I'm telling you that right now. So he can zoom in, he can appear with you, if you got to buy him lunch or breakfast, I don't know what you got to do, but his presence is necessary. Will, in your
Yes,
opinion,
sir.
will he in fact acknowledge that he's the biological father of that child?
Yes.
Okay. So what you need to do, I think you have the DNA testing between Mr. Bragg and Carson. Would you agree, Mr. Key, that those two people should submit to the DNA testing? So if that is high probability of paternity, then the court would feel comfortable excluding Armand Bailey as being the biological father of that child. So Ms. Bailey, you need to, first of all, buy the secure the DNA testing kit, and you need to have Mr. Brandon Bragg as well as Carson, just a saliva test. So get that done. Can you do that in the next couple weeks? Okay, you're muted, ma'am.
Yes, sir. Sorry.
Okay. All right. So Mr. Bailey, we're going to give you, Mr. Bailey, do you still reside at 7?
No, that's my mother's house. I live in California.
Okay. Mr. Bailey, give me a mailing address where you can receive these notices. The court's going to continue
well, no,
this
you can send it there. But I'm just saying, I live in California. That's my mother's house.
Okay. Well, you got a piece of paper and pen because the court's going to set another date right now. Keep the court's do ID number. We'll mail the notice to you at that Everett Street address. Let's look at a date. April, about April, the week of maybe April 26th. How about April 25th at 2:00?
Yes, Your Honor, I'm available at that time.
Okay. Right. Mr. Bailey, please make a note. This matter will be continued to April 25th at 2 p.m. Mr. Bailey, you still there?
Okay. Yeah, I'm here.
All right. Okay, you need to appear on April 25th at 2 p.m. And that should be we'll take testimony briefly from Ashley, you, and Mr. Bragg, and we'll have DNA test results, and we can exclude you as the father of this child. Understood?
Okay.
With respect to this divorce action, is there anything at issue, Mr. Bikini? Any joint property?
No, Your Honor.
Okay.
I've spoken with both parties, and both agree there is no property, there is no debt that needs to be settled. The only outstanding issue is the issue of the minor child.
Okay. In anticipation of Mr. Bragg's cooperation and appearance, perhaps you can even submit to the court a proposed judgment on that date, Mr. Keeney.
Yes,
I'll leave
Your
that
Honor.
to you. You can, if in fact it appears that all three parties will testify that Mr. Bailey's not the biological father, and that Brandon Bragg is in fact the biological father. So in anticipation of that and a DNA test, maybe we get the parties divorced on that April 25th date at 2 p.m.
I believe that's everybody's hope, Your Honor. So yes.
All right. So Ms. Bailey, keep in contact with Mr. Keeney. You need to move forward, get that DNA testing done, and make sure that you secure the presence of Mr. Bragg with you on April 25th at 2:00. Ideally, if he's with you in the same room, but if not, if he's working, he can zoom in from another location. But his appearance is critical. Okay. Okay, that will conclude this matter. You can all zoom out and record notice. Thank you. Parties have again conferred with Mr. Walker at the request of the court regarding the various outstanding issues, including the makeup 2 hours parenting time that everyone appears to agree that 2 hours, at least the recommendation is 2 hours to make a parenting time to mother, as well as some of her parenting time. So the court has received the following revised recommendations from Mr. Walker. His recommendation continues to be that all parenting time changes shall be at 9 a.m. From daycare or school. If there's no daycare or school, the exchange shall be at the Saline Police Department. Again, 9 a.m. So all exchange at 9 a.m. Mother shall make a parenting time. So presumably mom would drop off the child at 9 o'clock, then dad would drop off, mom would pick up then shortly thereafter. Is that correct? Mr. Walker, is that what is anticipated?
No, the opposite, I believe, Your Honor. That's dad's Monday, so mom would typically drop off at 9 a.m. and then dad would be able to pick up at 9. So mom is keeping the minor child until 11. So pick up and drop off would be at 11 a.m. that day instead of 9.
Gotcha. All right, so that'd be mom's weekend. So rather than mom going to take the child back to school at 9, mom could keep the child till 11 o'clock that morning. All right, thanks for that clarification. It's further recommended that each party should have 2 weeks of uninterrupted non-consecutive vacation during the summer. Mother shall have the first choice on even years. Father shall have the first choice on odd years. Of course, this is an even year. The party that has the first choice shall pick the vacation time on or before April 1st of that year. The party shall not take their vacation time during the other party's weekend. Further, that both parties shall complete the high conflict solutions .com workshop and to provide the 100-word essay. I want them to give some thought to what they have learned from this class, hopefully something, and they can share that with the court. So each parties will order to write a 100-word essay regarding what they've learned from the high conflict solutions class and provide that to the court. That's the guy's recommendation. Yes.
Do you, logistically, do you want us to submit that to the front of the court then? Is that how you want that provided?
Yes, to the court and the front of the court. The court wants to likewise see firsthand their respective essays.
Do you want those submitted under seal, Your Honor? Not as a filing then?
Correct.
Maybe just,
yeah, these were not going to the court file.
Okay, so just a proof of service that we submitted to the court and to the front of the court.
I don't know if you need proof of service. Obviously, if the court has received it, the court's going to bring it to the party's attention. So I don't know if you need to be that formal with a proof of service mailing. And I suppose good idea for the parents to exchange their respective essays. Well, what's your thoughts, Ms. Gorski and Ms. Kuhn, Mr. Chappell? Mr. Walker, what's your thoughts in terms of the parties exchanging their respective essays so their reflections can be shared with the other parent?
Great idea, I think.
Yep. No objection.
Any objection?
Nope.
Objection.
I'm sorry, Ms. Gorski, you're muted.
No objection.
All right, so the parties shall not provide to the court in front of the court, but they'll provide each other with a copy of that. All right, with respect to this recommendation, Mr. Gorski, and I understand your position is so the exchange should be at 4:30. What about the makeup parenting time, the summer vacation? Any additional concerns, thoughts, argument this morning, Mr. Gorski?
Yeah, I don't have any objection to the makeup parenting time. I think that the summer parenting time is poorly constructed. I think that the person who has the 4th of July under the front of the court holiday schedule should have the first choice every year so that they can incorporate their week with the 4th of July. Mr. Walker did not agree with me and is making his recommendation. I understand it. I do not agree with the recommendation, as you know.
Okay. What's significant about the 4th of July? Usually the first holiday is Memorial Weekend.
Correct, Your Honor. And Mr. Mancic knows that my client's extended
You
family
asking
comes into town around the week of 4th of July.
I'm sorry,
So
was
that's why
that
we didn't
recommendation?
agree. That's why we didn't agree, and that's why Mr. Walker made the recommendation of even odd years.
All right, I'm sorry, Ms.
Were you
Gorski.
asking me, Judge?
Yes,
Because
Ms. Gorski.
to answer that question, the answer is, for example, my client has the 4th of July this year, and he may want to take that week, like so many people in Michigan do, and go up north. It's my understanding Ms. DeBoot has family coming. Her family holiday is going to be interrupted by his 4th of July anyway, and she can, if she has that family event, she'll have it next year when it's her 4th of July. It just seems to me easier that whoever has the day of the 4th should be able to take their week to incorporate the 4th. Mr. Walker didn't agree, and I understand his recommendation. I don't agree with it. That's all.
All right, thank you. And I'm sorry, Ms. Kuhn.
Yes, Your Honor, I agree. May start summer, so whoever has the Memorial Day vacation or time would make sense. Mr. Mancic knows that my client's family is coming in around the 4th of July this year. Obviously, she's not going to take the 4th of July holiday because it is Mr. Mancic's, but she has extended family. So Maggie's aunts, uncles, a lot of people are coming in. So we found it really interesting that instead of using a May date, that the 4th of July date was the date that they had chosen. Given the contention with the case, Mr. Walker made the recommendation. We are in agreement with the recommendation from A to Z, Your Honor.
Judge, my client did not know that she has family plans. As you know, these parties don't communicate. He did not know that. It was my suggestion because it seemed easier. And with respect to Memorial Day, Judge, it's just that the child is still going to be in school for Memorial Day. That's why I just suggested the 4th. Whoever has the 4th would have first choice. That's all. It really was that innocent. I don't understand Ms. Kuhn's crazy accusations.
The child will be in daycare throughout the summer months too, correct?
Yes.
Correct.
All right.
But going
Well,
forward,
then-
she'll be in school at some point.
All right. And it's unfortunate because I don't know no matter what the recommendation is or the order of this court, it's not going to appease either party, which is unfortunate. And hopefully Mr. Mansky and Mr. Vood will learn to communicate for this child, because the child gets older, the child's going to sense there's really tension between the parents, and that child's going to be in counseling before we know it, which unfortunately, if they want this court, think about it, Mr. Mansky, Mr. Vood, you want a total stranger to raise your child. That's what's going to happen. You can't start agreeing upon these things. You should be flexible, work with each other for the benefit of your child, but if you can't, this court's going to make all these determinations where your child's going to go to school, what time parenting time will be, and really don't want a stranger doing that. But so at this point in time, the court's going to rely upon Mr. Walker and his recommendation. The court's going to adopt his recommendation. Again, that all parenting time exchanges shall be at 9 a.m., either from daycare or school. If there's no school or daycare, the exchange shall be at the Saline Police Department, begins at 9 a.m. Mother shall make a parenting time of 2 hours. That occur on should be on March 18th, 2024. That's a week from Monday, 9 a.m. to 11 a.m. With respect to summers, each should have 2 weeks of uninterrupted non-consecutive vacation in summer. Mother shall have the first choice in even years, so mom need to make that choice made to known to dad before April 1st. You shall not take your vacation time during the other party's weekend. And finally, both parties shall complete the high conflict solutions workshop and provide a 100-word essay in exchanges to the other party. Finally, is there a time frame for the evaluation from Dr. Wooten?
It's my understanding that he was making phone calls. He's completed his interviews with the parties and his observations of the parties with their child. And so I'm hoping that we see it later this month.
Okay. Do you want to, we've already taken the proofs. I don't see any need for another pretrial conference. I suppose once you get the evaluations, is your intent to schedule a mediation with Mr. Godfrey?
We have mediation scheduled for June 4th, Your Honor.
Oh, with the Godfrey?
Yes.
All right. Well, thanks for that update. I'll make a note of that. Do we have a June 4th at what time?
Well, I think we start at 9. It's all day.
Okay. All right. Well, the court will have the file available. The court will be available if the court can assist. So thank you for that information. All right. All right. That will conclude this matter. You can all zoom out. Have a good rest of the day. Thank you, Mr. Walker. The court will adopt the recommendation. Copy mailed out to counsel.
Thank you, Your Honor.
Thank you.
So you have that in front of you, that form judgment?
No, I don't have that. I just have the paper that to log in.
Oh, looks like you returned that proposed judgment to the court.
Oh, yes. Yes, I did do
Okay.
that.
In any event, Mr. West, what's your discharge date? Yeah, you're muted.
We can't hear you.
Mr. West, we cannot hear you. You did something with the, you must have muted yourself.
He's not muted, maybe just.
You turn up your volume?
Can you hear me?
Yes. What's your discharge date, Mr. West?
April 30th of 2025.
Okay. All right. So, okay, Mr. Walker, do you mind talking with the parties, please? It appears it's a 3-month marriage. Well, let me ask you, maybe rather than take Mr. Walker's time, is there anything at issue? Do you have any joint debts that need to be addressed, or no children?
No.
There's no property, no pensions, no credit card debts?
No.
Would you agree, Mr. West?
I mean, the only issue I have with this is my grandma's $1,200 phone that she has. My grandma has the receipt. My mom has text messages of her saying that she's got it. She won't give it back because she said
Okay.
that I racked up T-Mobile debt.
Okay, so it's your grandmother bought a cell phone, and did she give it to Miss West?
No, Brianna got locked up with it. And when she got out of jail, she had it.
Okay, Miss West, do you have that cell phone? Are you willing to give it back to his mother?
No, I turned the cell phone in. The cell phone was in my name and it was being paid for still. And so I owed money on it. So I turned it in.
You turned it in where?
T-Mobile.
Oh, so it's just you didn't buy the phone, it was just a rental phone?
It wasn't rental, it was like a financing. So a deposit was put down and then we had to pay on it every month. And then we both got locked up and the bill didn't get paid. And then I owed money on it. It's all on my credit.
So they turned in the phone to eliminate the debt. Is that correct?
Yep.
And the debt was always in your name. It was not in grandmother's name.
No, it was in my name. The phone was in my name. She just put the deposit down on it.
Okay. How much did it? What kind of deposit did you put down?
I don't remember. I don't have the receipt.
I'm sorry. How much?
About $1,200.
$1,200 deposit on the phone?
No, it wasn't. That's how much the phone was worth.
Okay.
I don't remember the exact amount that it was. It was probably about $600-700.
Wow.
Okay.
So, Mr. West, if it's in Miss West's name, that's between your mother. Your mother can take her and file a civil complaint against her to recoup that money. I don't know if this was a gift. I don't know why she would buy a phone, put a deposit on a phone, but put it all in the name of Miss West. But it doesn't sound like that's a marital asset. That's if in fact your mother feels that she wants reimbursement from Miss West, and she could file a small claim action against her.
Okay.
But again, it appears that that's been turned in. Now we can take sworn testimony from Miss West this morning. If you doubt that, she can testify under oath that she does not have the phone. She turned it in exchange for discharge of this debt in her name.
No, my mom can file.
I'm sorry?
That my mom can file that in small claims, then that's just what we'll do.
All right. So you agree there's nothing really at issue then, correct? I mean, if Miss West wants a divorce, this court, it's a no-fault divorce in Michigan, and the court must grant her judgment of divorce. Do you understand that?
Yeah.
All right. So the court has a Form 2-page judgment, Mr. West, that this court can, with your agreement, consent, this court can fill in the blanks, just checking the boxes. I put my initials next to that, and if you and I can just simply indicate that you appeared by Zoom today and you approved and consented to this court approving this, entering this judgment on your behalf. Any objection to that?
I do.
I'm sorry?
I said I do.
Okay, for the record, this matter is before the court for a pretrial conference, same as being conducted via Zoom. Both parties are present. And the court had a brief conversation with them. Mr. West is incarcerated in the Chippewa Correctional Facility, Northern Michigan, with a discharge date of April 2025. Court would note this is a 3-month marriage. Parties have been separated since September of 2022, over a year and a half. And there's nothing at issue. There was a brief discussion on the record about a cell phone that Mr. West's mother paid a deposit on. However, that phone was in the name of Brianna West. The debt was in her name, and she's to turn that phone in back to T-Mobile in exchange for discharge of that debt. So any request on the part of Mr. West's mother for reimbursement of that deposit can be pursued by virtue of a small claim complaint or civil action by Mr. West's mother. So can you both please raise your right hand to be sworn, please? Ms. West, is it true that you filed a complaint for divorce with this court on about December 4th, 2023?
Yes.
Is it further true that on the date you filed the complaint, you've been a resident of the County of Monroe for at least 10 days, the state of Michigan, at least 6 months?
Yes.
Is it further true that you married Nathan West on June 9th, 2022, and you separated in September of 2022?
Yes, sir.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed? There's no reasonable chance of reconciliation?
Yes, sir.
Were there any children born or adopted during your marriage?
No, sir.
Are you currently pregnant?
No, sir.
Mr. West, can you please state your name and current mailing address for the record? 4269 West M80. I'm not sure you pronounced the city. Kinchelo?
Yeah, Kinchelo.
Kinchelo, Michigan. Right, Mr. West, did you hear the testimony this morning of your wife, Brianna?
What?
Did you hear the testimony this morning of your wife, Brianna?
Yeah.
Was her testimony true and accurate to the best of your knowledge?
Yeah.
court is going to walk through the terms of judgment with you. And I'm going to check, I'm just going to X boxes. And I'm going to, whatever, with the box I'm next, I'll put my initials by that. First of all, the first box is spousal support. This is not an alimony or spousal support case. It's 2 short-term of marriage. You're both young. So the court's going to X the box that neither party's awarded spousal support and it's forever barred. Is that agreeable?
Yes.
Personal property. We've already talked about the cell phone, and there's 2 boxes. Either we divide personal property or we say that each party is awarded the personal property currently in their possession, free and clear claimant part of the other. Is that agreeable?
Yes.
This message is for James, Kayla. Hope he's looking. He's not looking. Hold on.
Can you hear me now?
We can hear you, but this is for James. He doesn't have any audio, but we gotta get his attention.
He's blind, so you would have
Can you text him or something? I don't have I can't text him by phone. Someone's gonna have to.
Okay, 1 second, please.
Hello?
Hello, can you hear us?
Yeah, now I can.
Okay, good. You can hear us now.
Okay.
We'll call the case of Kayla Gray versus James Gray Jr. For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. It appears that we have both parties present. Are you Kayla Gray? Yeah. Need to unmute yourself, ma'am?
Yes, ma'am.
Okay. And sir, you are James Gray Jr.?
Yes, I am.
All right, good afternoon. Courts receive a post consent judgment. One thing that the court wants to address, first of all, Ms. Gray, are you still receiving public assistance?
Yes.
Okay. The reason the court's asking because there was a waiver of a filing fee. Mr. Gray, do you receive public assistance?
Yes, I do.
Okay.
I get Social Security and food stamps.
All right. Currently, will accordingly waive the filing fee. All right, can you both please raise your right hand to be sworn?